First, followed by Rajat and then ISHRAT Alam. Najaf.
Thank you. I want to thank Nalsar and Max Planck Institute for giving me the opportunity to come and participate in the workshop and make a presentation, particularly to Professor Faizan Mustafa, who agreed to let me speak on a theme which doesn't quite fit the remit of the workshop, but maybe it has potential to be developed into a fully fledged paper on law, identity, and local administration. It's about a particular episode in the life of a small merchant in the 17th century. Who narrates this incident in his autobiography. The merchant is Banarsi Das, and the name of the autobiography is Ardh Kathanak, or Half a Tale. He was a Jain merchant who followed the Jain cosmological understanding that the lifespan of an individual is 110 years. And when he reached 55, he decided to write his autobiography, and hence call it Ardh Kathanak, or Half a Tale. It's in Braj. It's in Braj, laced since Banarsi Das straddled between Jaunpur and Agra. It's a Braj laced with Eastern Hindi, some Awadhi, and some script is Devanagari. We are not discussing the aspect of truth and design in the autobiography, because generally speaking, a large number of episodes which are mentioned are accurate and can be tested with the help of not only the internal evidence that is available in the autobiography, but also external evidence, particularly the one which I am going to discuss, which I tried to test using whatever material I have. I'm so sorry, it's my phone that is ringing. So I took this episode to be some kind of an illustration of Mughal administration of law and order at a very low level of the Mughal administrative hierarchy. Usually we are familiar more with metropolitan cities and how law and administration worked in these centers, but to gain an insight into how the Mughal administration works and how the question of law is posed and treated at the level of a township just above the village or qasba is what really is interesting in this. And of course, the question, what was the role of the Mughal law, what was the role of Sharia law, and which I am treating both as law and Islamic law, because following Professor FARHAT Hasan's discussion, it's possible to see how the word Sharia is used in a much broader sense of law and administration, as opposed to a sense in which it's technically defined as a body of Islamic laws and opinions. Now the episode is of Thagi, or a particular crime for which there is very little evidence in Mughal or pre-Mughal period, and that's also why this is important. Banarsi Das is traveling from Jaunpur to Agra to close a partnership arrangement with a big merchant house in Agra. And he has a retinue of servants and horses, and in a place called Ghesua, which is modern Machli Shahar, very close to Jaunpur, he meets another merchant who was also traveling to Agra, a big merchant who is identified as Mahesuri, and who was traveling with his servants and he had a retinue and 2 Brahmins who were going to Mathura. So they decided, when they met, they decided to stick together and travel as a caravan, as a group, and not to part. This is something which Banarsi Das talks a lot about, that we decided, we took a vow that we will never. Little did they realize that this was going to be a huge problem for them. When they reached a place called Kora, or Kara today, near Fatehpur, they stayed in a sarai or an inn, and there this is a map of, I don't know whether you can see, this is a map of the Sarkar of Kora, the Mughal administrative Sarkar of Kora, with the Pargana or Qasba level, district is the Pargana level, and the city of, and the Qasba of Kora right there in the middle with a dot and a circle. Now, in Kora, the 2 Brahmins went to meet a woman of easy virtue, and they wanted to buy some fruits and sweetmeat for her, and therefore they went to a money changer to change money. Now, in Mughal India, you can't go and buy things directly if you don't have the right change. It's something similar to what is happening today. So, if you have a silver coin, and if you want to buy something the price of which is stated in a copper coin, then you have to change the money. So they had silver rupees of Jahangir, which they went to change into copper coins in order to buy whatever they wanted to buy, and then they went to this woman. There, the Sarraf came with his brother, who was also a Sarraf, and charged them with the crime of circulating counterfeit money. Okay? Luckily, counterfeiting in those days was not a big crime, as we shall see. So, and there was a fight. There was a fight in which the 2 Brahmins beat the Sarraf, and the Sarraf then went back and drummed up support for his side, and they all went to the local Mughal officer or Fajdar of the Sarkar, where the charge, interestingly,
Sorry, I should be interrupting you, but Brahmins, they are traders. No, the Brahmins.
no.
2 Brahmins. Okay, in their retina.
See, the Brahmins apparently were also traveling on their own, and when they found that there is a caravan going to, and since Mathura is on the way to Agra, they decided to. So this is incidentally the only surviving Mughal painting of a Sarraf, which is in the BNF Paris, and it's an actual painting and not an ideal type, because if you zoom in, you can read the legends on the coins, which are actually the inscriptions you will find on Mughal coins. And incidentally, there were women also, but apparently this is a different. Now, the charge which was brought against them in the court of the Fajdar was not of counterfeiting, but of Thagi, which was a very serious charge. And the word Thag is used, and it was argued that they are in a group, and group identity is a very important feature of Thagi. They always travel in group, they stay in sarais, which is all narrated to the Fajdar. And also, the most interesting criterion for judging the crime, they practice deception. And one major thing which was absent, but it's discussed in other sources, is that they also strangle their victims, which was a very, both deception and murder together. So that was the charge. They were arrested, and a police picket was stationed outside the Sarai, and the Faujdar of the Sarkar sent two officials, the police chief and the officer in charge of the finances of the Sarkar, the Diwan. So Kotwal and Diwan both came to the Sarai, and there was a trial right there. And in that trial, they were, of course, asked who they were. That's the first question they were asked, because nobody knew them in the village. They were travelers. So the first question was to ascertain their identity, who they were, and they all explained who they were. Each particular person, the merchant Maheshwari, Banarsi Das, as well as the two Brahmins, their statements were recorded, and some of this recording is reflected in the autobiography of Banarsi Das. After that, there was a discussion between the two officers who were speaking in Persian, which Banarsi Das could understand but not speak. So he recollects the conversation, and in that conversation there was a tension. One, the police chief was saying there is all this evidence that they are thugs, and the Diwan was saying no, there is not sufficient evidence and we should do further investigation. The interrogation was concluded, and they went back. And that night which Banarsi Das and his co-travelers spent in the Sarai was a very difficult night, and Banarsi Das has something like 20 verses. It's a versified autobiography. He said something like 20 verses on what happened in that night. In the morning, to their great horror, they saw stakes being installed for their execution right there. And there was one laborer who was bringing the stakes who said, "Ye aapke liye," which was hardly a comforting thought. Yes, this is for you. Then the Diwan came in the morning, and this is the conclusion of the trial and also my presentation, which is that the Diwan gave them the opportunity to produce somebody from the neighboring village who could identify and validate their identity, and their entire the case and their execution and freedom rested on their ability to get somebody from the nearby village, and there was somebody. Incidentally, during the conversation which they had in the night, towards the end, when the twilight was brightening into dawn, Maheshwari said to Banarsi Das that I now remember that my brother is married to a village nearby. And Banarsi Das was very angry with him. Why didn't you tell me before? He said, but he was happy also that there would be someone. In the morning, the police chief and some policemen went with this person, Maheshwari, to the village. A man came who validated the identity of this person, the merchant who was traveling with Banarsi Das, and by virtue of that validation, the entire group identity was validated and they were exonerated, liberated, and then Banarsi Das thanks God and goes to the various officials and give them gifts and all that. So this is the episode. Now, what can we do with this episode, which, as I said, appears to me to be an accurate recollection of real life incident in his autobiography, to which he attaches a lot of importance. Now, our sources are not clear on the nature of the crime. That's one thing which I noticed. The thugs are identified as swindlers who cheat by deception, who rob, who strangle. So there's a whole spectrum of criminal activities which are attached to this particular charge of being a thug. We have evidence of thugs being caught in Delhi by Jalaluddin Khilji, and this is early 14th century. And then he just asked his officer to deport them. So deportation was a major major punishment. Thugs in the 16th century are often identified with highway robbers, and it was only after a trial that it was ascertained whether they were simple robbers or they were thugs. And we'll come to an interesting incident in the life of, if time permits, a Christian friar who was traveling in Bengal and who had a similar experience. Now there were three sets of laws which operated in Mughal India. There was the state law, which was formulated by the court of the king in consultation with his officers, particularly the chief judge or Qaziul Quzzat. These laws were variously termed as Zawabit, Ain, Dasturul Amal. There are various terms which are used. You can call them regulations also, because some regulations acquire a degree of consistency only after a period of time, when there are further farmans issued to buttress those regulations, and then they become something like a law. Then there were religious laws, of course, Sharia, Dharam Shastra, and canon law of Christians in India. And of course, we have been talking about this, there were customary laws, which were largely customs of localities, caste and professional groups and their institutions. And these customary laws also were acknowledged by the state as valid frameworks within which disputes could be tried and arbitrated and convictions could be given. Now, in many cases, as Professor FARHAT mentioned, there can be seen a blending of laws, leading to the emergence of some kind of a mixed legal system in which certain state laws dominate in certain areas, such as rebellion, political crimes, where only state laws function and there is no interference of either religion or custom, and mercantile disputes, for instance, which are determined entirely by customary laws, unless there is a petition to the higher court in which the governor of the Subedar, or later on the imperial court, had the opportunity to try a case, and we have many examples of that too. So sometimes it's very difficult to trace the provenance of a particular law, where it originated from, because after a time it appears as a standard law and practice in the books of the Mughal administration. Well, this is just to give you a sense of what was the hierarchy of administration of law and order. There was this civil law, which also included laws relating to religion, which was the person in charge, the officer in charge was Qazi, and then in Jahangir's reign, Kashmiri Pandit was appointed as the counterpart of the Qazi, who would administer the laws of who will look after the laws of the Hindus. We are dealing with this particular set of people in the Sarkar. Interestingly, there is no Qazi in this whole episode. There is also no local hereditary official. The village headman is not there, and other customary people who are in charge of the village administration. Village administration in Mughal India was entirely independent of the Mughal state. They had their own hereditary officials who were allowed by the state in some way to function, but they were not appointed or paid or dismissed by the state. They were quite independent, but there is no single village official who can be seen at this level. This is an interesting aspect of because we always think that local administration had a major role to play in the affairs of the village and the qasba. Now there was a Mughal law against counterfeiting, and you can see that it's described in Aurangzeb's Farman of 1672, which says that if anybody makes counterfeit money, at the first level there is this process of ta'zir or chastisement, in which the person is given a dressing down and he is asked not to practice this. and then he's let off. But then if the offense is repeated, there is this punishment of tahdid, which is, no, I'm sorry, tahdid and tazir go together.
Admonition.
Yes, so tazir is and tahdid go together. Then in the second offense, there is this imprisonment also, which comes with chastisement till he repents. And I don't know what exactly that means. And the man can repent, but the officer in charge may not listen. Or then if there is a particular, because we know that there were prisons, not only at this level, but also all other levels, called Bandi Khana, a very interesting term, which is a mixture of Hindi and Farsi, where these people were kept. Now, repeat offenders, if they do not desist, then they should be executed. That's the law. The law against Thagi is harsher, because that intermediate level of chastisement is not is simply not there, and in the beginning, yes, he can be chastised, but then there is no intermediate level of imprisonment. If he's a repeat offender, and in this case, as we can see, there is no first level of chastisement. They are simply charged, convicted, and pending their validation, they are ready to be executed. Now, interestingly, this entire law on counterfeit and Thagi is lifted from Fatawa Alamgiri. All goes into Fatawa Alamgiri from this farman. The first is more likely to be the case. So it's also an interesting way to look at the content of the Fatawa and see how much of, to my understanding, this is a very rigid, fixed, immutable set of laws. It can be read in a court of Baghdad or Nishapur or Egypt. It's the same law. And I was speaking on something else in Istanbul, and there was a lady who gave a presentation, and there the laws appear much to be the same as for highway robbery, as we can see. So this is an interesting example of the rigidity of and very close correspondence between textual, scriptural formulation of the law, and both in Fatawa Alamgiri and the Farman of Aurangzeb, and I see no difference between the two, which suggests that there is a greater degree of latitude left in the hands of the officials to try cases and decide, and that's the reason why a Qazi is not there. Not to say that the Qazis also did not have latitude. Qazis have tremendous latitudes. They were judges, not Muslim or Islamic judges. They had tremendous latitude to try these laws, to try the cases on the basis not only of Islamic law but also customary and state laws. So finally, I would like to end here by making 2 or 3 points. The first point is that this gives us a firm evidence of the crime of Thagi in some detail, and also links it up, and I don't know how far this is accurate, with a phenomenon which occurs in Bombay, Maharashtra and Western Deccan or Bombay Presidency in the 18th century, where a group of people called Chaparbans are, Chaparbans who are counterfeiters and thugs in one, are arrested, tried by the British officials, and as a result a huge body of literature is produced on this group, including their ethnicity, and so that's one point which I find interesting. The second point is that we can see how the process of trial works and only a glimpse, it's not a blow-by-blow account, only a glimpse of it. And finally, that this episode tells something about the normative principles or normative legal structure of the Mughal judiciary, as well as the role of the Sharia in at least giving a framework in ordinary circumstances for trials and conviction. Thank you.
Yeah, I just like I just need a couple of minutes.
Just see if it was working a little while ago. So I presume unless until it has been just want to make sure that it does work. Okay, thank you. With the usual, thank you very much for having me and amongst, I mean, this is my first seminar on law that I'm attending as a historian. So I don't know whether I should be the cat or the pigeon among the cats, but nevertheless. And I'm not speaking on law at all, I'm speaking on governance, and this is something which again emanates a little bit from what FARHAT was talking about yesterday about bringing the state back in. And I'm going to bring back the state right in the construction of an early modernity for this period. Now, why I call it political economy and governance, because I'm an economic historian and a leopard finds it very difficult to change its spots, so I have to look for economy wherever I put my foot in it. But political economy is a little more wider because it sort of talks of an intersection of politics and state with with production, distribution, and circulation. So how the state intervenes in regulating or retarding or enabling, economic processes becomes political economy. And that also links it up with this question of governance, because governance is not just about ruling, it's about ruling with an ethical foundation and in the frame of law. So it is also has to be participatory, consultative. So it's a total process, not just the use of power. Though power, of course, inheres in everything. I mean, we don't necessarily have to refer to Foucault all the time to understand that power is everywhere. But it's power which is also subject to scrutiny and regulation both within and outside. So it's a self-regulatory as well as it's subject to external scrutiny, which makes it different from a kind of whimsical use of power, which is a sign of despotism. And at another level, some bit of accountability. So having said this, what I'll do is I will go through, there's a little paper that this is a kind of work in progress, like, or for all of us, there's a lot of work in progress, but it never finishes. So it's one of those, on the question of early modern India, which I'm now in the midst of, writing, written a number of papers and published a few, and probably will somehow at some stage get it out into a form of a book. So it's all leading to that. And the question of early modernity is incomprehensible without understanding the state. And not merely the state as a regulatory mechanism, but as a state as an enabling. How does the state enable new economic processes or new ideas or new intellectual processes to enter and to circulate, because it does become a fulcrum of circulation. So what I'll do is, there's a little presentation, then I'll have 7 or 8 slides which I'll quickly run through, because these are this is I'm not dispensing with the evidence, but the evidence is, there are too many quotations for me to, from primary material to read out, because that I'll need an hour, and nobody's going to give me an hour, and certainly not, I'm not deserving of an hour, because the quotations are longish. So I'll just run through the quotations as part of what, and so kind of, it's on the basis of these that what I have to say is emerging. Now we know that there has to be a close connection between the state, good governance, and good economics, and that's obvious, but not so obvious in today's India, but nevertheless. But what perhaps is not obvious is how exactly does that take place, particularly in a period which has gone by, times past, and also in what may be broadly called non-European contexts. In the European context, there is an embedded idea about the immanence of modernity in Europe, which we don't accept and we strongly contest. But the idea of the immanence of modernity in Europe has been of a very long standing. And therefore, there's a comparative problem here. That how did European states govern and manage their economies? Did they manage them better than Asian ones? And if so, how? And if not, why not? There's a comparative problem. One area where some historians have argued is, compared to Asia, European societies were homogeneous, and it seemed to have worked to Europe's comparative advantage. For instance, a person like David Landis makes that argument, or Perry Anderson makes that argument. So therefore, the immanence of modernity in Europe is Eurocentric, and therefore any idea of understanding early modernity has to take on this issue of Eurocentricism in the understanding and the conceptualization of modernity as a process and as a full-fledged formation, though of course very difficult to pinpoint. Now there is that edge of European economic history or political history writing which sees for Europe and uniqueness, but there are more nuanced, in recent years, more nuanced and critical appraisals of the process of modernity in Europe, in which basically it is seen that conflicts between state and citizens is a very embedded part of the process of early modernity. Powerful landed gentries enjoyed their privileges for a very long time in Europe. The state could only function through a web of patronage and clientage which stretched from the royal court to the local communities, and therefore there's nothing sort of implicitly exceptional about the so-called mercantilist state in early modern Europe. Now, there are many questions, and I can't enter into those except to say that the state has a role, and this role is very important. How do you conceptualize this role as far as this period is concerned? Now the question is how much economic influence could the early modern European state exert is a moot point. Nobody really has been able to demonstrate that, except that it had a potently fiscal role. The state's role was basically a fiscal manager, because in the state you combine fiscalism, monarchy, bureaucracy, military together as a single receiver of income and the largest single spender. So in early modern Europe or early modern world, the state is the biggest consumer and the state is the biggest buyer, as it were. Now, when it comes to India, when we look at the economic problems, we try to figure out how do we relate this to India, and this view is not difficult to clinch, because there are kind of two contending views about the state in early modern India. One is, of course, the state as a kind of blood-sucking incubus, the state, the kind of predatory state which did not do anything except latch on and extract the surplus and destroyed everything along the way. In recent years, there are some more attempts to understand the place of the state. Here, what is argued is the state emerged as the greatest manager of in the sense of how do you differentiate, how do you place the position the state? The second kind of a view that is being expressed is that the state was not that the state was a predator, but the state was unable to consolidate and manage the gains of commercial expansion and in managing the impact of the world economy in the 17th and the 18th centuries. The state, therefore, is an ineffective economic player. It's not necessarily a predatory state, but compared to Europe, an argument is, for instance, by Prasannan Parsarathi, is that this is the differentia specifica. In Europe, the state is a better manager. In India, the state is not a good manager, and therefore mercantilism is not an option in the Indian context, which apparently, of course, seems to have characterized Europe's and the connection between the economy and state in early modern Europe. Now, my paper tends to argue that it takes a contrary position. It takes a contrary position to both positions. It argues that the 16th century onwards, up to about late into the 18th and early 19th centuries, saw complex institutional and political interfaces between the state and new impulses emanating from expanding agrarian and maritime economies. The stimuli of an early modern world economy was beginning to surge into India through a globalized maritime system, which was spatially and economically diverse, but converged on India's agrarian economy, and that is why the importance of taxation and revenue becomes a very important entry point into understanding the state in this period. There were large rural magnates who had wrested critical economic leverages, so the state had to deal with them. There was agrarian expansion and monetization, which threw up a class of stratified peasant society in which rich peasants existed. And the state had to operate through them in order to set up effective systems of measuring the area under cultivation, arazi, and to establish a workable schedule of prices and revenue rates for different crops based on measurement of cultivated acreages. In that respect, the state now began devising new techniques of governance in order to create new synergies between itself and diverse agrarian regimes under its rule. Therefore, it's not a uniform state. The country is too diverse to have a uniform state. So therefore, the diversity, management of diversity is a very important part of governance in India. This enabled it to manage and simultaneously reap benefits from expanding agrarian and maritime opportunities without having to control one or the other. This, in my view, explains the ability of the early modern state in India to both successfully extract high levels of agrarian surpluses and ensure unprecedented degrees of political and social acceptability within diverse demographic and social and cultural milieux. Now, Asian experiences of early modern had a slightly somewhat different set of parameters of how you should measure the experience of early modernity in this part of the world compared to the West. I have about 6. There's first of all, the territorial and fiscally redistributive polities. Secondly, unprecedented maritime-oriented export expansion, intensive monetization and a pervasive cash nexus, expanding non-agricultural production, particularly in craft and agro-processing industries, a proto-capitalist combination of commercial farming and craft production in the countryside, urban growth and complex divisions of labor within towns and between towns and country, and finally great webs of markets and marketization processes, particularly in rural and intermediate zones below the urban centers. And therefore, the fundamental point of convergence here, despite the massive diversities of Asian and Indian societies, were the economic networks fostered by long-distance maritime trade and how they interface with local society. Here, the state had a very important provisioning function. The state not only collected revenue, the state redistributed revenue. And it's between this collection and redistribution revenue that you find a very important aspect of how to govern and manage agrarian diversities as well as to establish a certain degree of uniformity. Now, therefore, it would be fundamentally methodologically erroneous to seek a pan-Indian version of mercantilism in a context in a context marked with such immense diversities. Secondly, I would argue that the Mughal state and the states subsequent to that were all concerned with the fiscal, not particularly tilted in favor of mercantile protectionism, but the distinction is fine because a lot of what we understand to be mercantile is not necessarily overseas, not maritime. So therefore, one has to differentiate between what is maritime and what is mercantile. These two are not necessarily the same. And then, of course, there is the question of agrarian governance, which is something which I want to talk about in the next couple of minutes. I argue that there are three variables which are quite different and in many respects new, and the convergence of these three variables calls for a new look at what constitutes governance. First is the co-option and cooperation between the state and the revenue payers. It's not a matter of coercion alone, it's cooperation, coercion as well as co-option. These are the three dynamic points through which revenue is collected and transmitted. Therefore, it involves negotiations through complex indigenous terminologies and linguistic diversities in both usage and practice. When I skip through my slides in a minute, there you can see that. The second is the way in which rights over land, perquisites and rights over land, and the connection between rights, prescriptive rights, and ownership. And my argument is that in this period, there is a consolidation of private property in land, which the state defends. The state defends this consolidation of private property and private ownership on land to the point that, except when it becomes rebellion. I mean, we are not talking of situations of rebellion, we are talking of situations in which private property is seen as an important step in the collection of revenue, consolidation and a guarantee of private property. Then it was also a question of pragmatism, that how do you shape a policy to tackle, to have responses to changing situations, and we'll see how that is done. But two important points which I want to make before I switch to the slides and talk about them in a kind of conclusive kind of way. The two important areas where you see the state actually enabling economic processes is, as I said, one through the expansion of milkiyat rights, expansion of the idea of property, and the second important point at which the state is enabling new dispensation in the economy but through governance is by the idea of contract. Contracting is a very important part of the negotiation process as well as delivery process. And contracts have different terminologies, contracts have different resonances, but contract is a very important part of the way in which agency, individual agency, is not, so therefore the argument that everything is corporate, organized as a community, as a kind of inchoate whole over which the state and collects revenue without any agency of that inchoate whole is not true. Contract is a very important part of individual agency fitting itself into the state. So this is where I want to go switch on to my slides, and just to bring you up to date, this is at the moment, this is the sort of evidence which I have, on which I'm thinking, as it were, on these three issues. One is the issue of negotiation and the way in which individual agency is supposed to dovetail with the state. So you're looking for people, when I said it's cooperation, co-option, and as well as cooperation and co-option. So these are some of the issues which are important as far as that is concerned. How do you collect taxes? It's a very important part of the state's problematic. How do you collect? Do you beat people up, or do you get them into a system where they pay, but you give them a choice? And that giving them a choice is a very important part of in a monetized economy. That's one level in which this is happening. Then the diversity. Diversity is on the basis of how does the state maneuver through the diversity. There's a linguistic and cultural diversity. where different languages, different vocabularies, different revenue terminologies are in vogue. How do you cut through those in order to standardize something? And how do you allow people the flexibility to come into the system as revenue payers? So where I look in the last two quotations, I look at Sher Shah's exhortation to the cultivators that I give you a choice. You want to pay in cash, you want to pay in kind, but once you make up your mind to pay either in cash or kind, then you must pay, because otherwise then what's the point of giving you the choice? You can't get the choice and then decide that I don't want to pay unless and until there's a problem. If there's a problem, it's a bad harvest, there's a problem, well, we'll sort it out. But that is not, and therefore the timely deposit, timely remittance of revenue is a very important part of an obligation of a citizen. So this is where the choice comes, and this is where Abul Fazl comes in one of the most significant passages of the Ain-e-Akbari, where he's talking about what it means to be a revenue collector. Then what kinds of revenue are being collected? Kankut, there is Galla Bakshi, there is Batai, there is Khet Batai, there is Lang Batai, there are Nask, there is Zabt. There are about 8 or 10 different varieties in which peasants are being enabled to pay their revenue. So standardization is, the idea of standardization is basically the idea of diversity. And the way in which the diversity unfolds is also an important part of the way in which the state rules. And this is from Bengal, which is kind of where I've seen some of these documents. And it's important that all the documents that talk about the reference point is Todarmal. That from the time of Todarmal, from the time of the Asal Jama'at, this is what has been happening in Bengal. So there's a benchmark which is being referred to by the intervention of Akbar and the way in which the regulations are constituted, which is seen as a departure from the past. So that is a critical element in which one sees that 16th century onward is not the same. There's something very different from the 16th century onward. So milkiyat, definition of milkiyat, how do you become a proprietor? So Tangalbari, Intikali, Ahukmi, and so on and so forth. Then I move on to a question, then again, these are private domains being constructed on the basis of purchase. So you buy land from a zamindar, you become a talukdar, you sell it, you become a talukdar. So there is, how do you differentiate between different forms of landed property? And these are not merely prescriptive rights. You have tax collection rights, but you don't have it because, you have it because you buy it. The idea of kharid farokht, and there are talukdars who are called kharid farokht talukdar. So that's a very important part of being the consolidation of private property in land. Again, when the East India Company comes, Reza Khan explains to them that what kind of zamindars exist in Bengal, what kind of landed, what is the hierarchy of landed property that exists in Bengal. And here again, Kharida zamindars, Jangalbari zamindars, Sanadi zamindars. So zamindar is not merely a question of state largesse. You can become a zamindar if you have the money and you buy and you become, so you need a sanad, fair enough, to recognize you as a zamindar, but it's a deed. Then, sorry, here. Now, that last point is about contract. So what kind of contracts? What are the terms which are used for different levels of contracts? And here is the kind, here are some of the there are 6 or 7 ways in which contracts are defined. There is Kabuliyat, there's Qal Nama, there's Qarar, Muchalka, Mutahadi, Tamassuk. These are the 7 ways in which you can enter into different kinds of contract, from land to was written undertaking from a borrower promising to pay a loan within 2 or 3 months. So commercial contracts to landed contracts and so on and so forth. So this is where, this is the kind of picture, broad picture of agency, individual agency, volition, statecraft, and fiscal governance comes into play in this period. And finally, I just want to rush you through a couple of orders from the Sadr Diwan-e-Adalat, where you have the ways in which RZ is documented, the way in which an agreement is documented as far as land deeds are concerned, and then you have sale of land and a purchase, sale and purchase of land, where you have witnesses and where you have a signed deed and where you have an agreement and so on and so forth, where the genealogy of the buyer and the genealogy of the seller are traced and recorded, and kind of the deed of agreement. And finally, I have I end at Qararnama. I'm sorry, I missed out the Qarar. R is missing in that. That to produce somebody to court, that I give a undertaking that I will bring this person and produce him at your court on such and such day. Otherwise, I stand to forfeit 25 rupees, which is a huge sum of money in 1796. Yeah, Muchalka is an agreement, but he is giving what is called an affidavit in court. This is close to what you would call an affidavit in court, that I swear that I will do this and this and this and this. Otherwise, I am liable for criminal prosecution, which is the kind of system that. Yeah, surety. That I stand surety. I stand surety. Yeah. But it has to be a signed on bond paper and so on and so forth. Yeah. Thank you very much.
Was it on a plain paper or there was some special paper also?
There was a plain paper that had to have a sign, had a seal of the Diwan. The seal of the Diwan is always there, Qazi and the Diwan, or the seal of the Pandit, depending if you are a Hindu.
Because यहाँ पे हमने in Telangana recently, we persuaded the chief minister to सादा पैनामा, जहाँ कभी stamp paper and plain paper पे करो जो मोहर लगा दो, वो बड़ा
It is not a plain paper. They don't have a. But the Qazi seal is embossed seal. Yeah, embossed seal is there.
No, I'm fine standing. Well, first of all, I would like to thank Professor Faizan Mustafa, Vice Chancellor Nalsar, and the authorities of Max Planck Institute for European Legal History. Is it audible? Because I have a very sore throat because of cold. And the respectable audience. Well, I have a very tentative paper before you to be presented before you. It's called Law and Customs Relating to Foreigners in the Mughal Empire, of which most of the parts have been luckily dealt by since yesterday by Professor FARHAT HASAN, then NAJAF following him, and just now Professor Datta spoke about a lot of things. I shall be providing some fill in the gaps kind of material. The question arises that the formal Islamic jurisprudence remains enmeshed in the fiction of caliph or imam or a single law of enforcing authority in the entire Muslim community. Was anything of that sort was there or not? Does not have any. Was there any provision for a situation in which one caliph but various sultans are in independent sovereign controls of different parts of Darul Islam, Islamic world, or Darul Harb? In other words, there is a very complex context where the context where relations between sovereign states, contact between subjects of various states, law of the various states, I mean the foreigners, law of the high seas, etc., are not known to Islamic law or world. However, in all these spheres, conventions and practices developed, which Najaf just now said, under various influences, among which mercantile customs also had perhaps its due place. They are incidentally referred to by historians when they either condemn or compliment or refer to ill treatment of subjects of another ruler. In such kind of quotations we find certain references. They also figure in litigation, and such documents of jurists as fatawas or interpretations Without going into all these details, there are many other things which we can find in the written form. One question which immediately comes to our mind is the question of compensation if they were subjected to as thuggy or robbery or extortion within the towns or on roads in delight. In Ain-e-Akbari, composed in 1595, we find this responsibility being assigned to the Kotwal. So the state was conscious of this, head of the town police, and outside the town on the revenue collector. Shah Jahan's regulations, we find within court, I would say, if anywhere anything is lost, the officers having revenue jurisdiction, these are obliged to pay compensation as well as fine for their negligence. Chandrabhan Brahman also speaks about this. Then Manucci in 1700 recognized this prevalence of this regulation when he says, the Fajdar have to supervise the roads, and should any merchant or traveler be robbed in daylight, they are obliged to pay compensation. In the Mughal administration, we find lack of any distinction between its own subjects and foreigners, subjects of other sovereigns. In 1619, there was a robbery of the company's Karwa, English East India Company's Karwa, which occurred, and the local Qazi, whom the English East India Company record says, the notary public issued a certificate of loss, and the obligation to pay compensation fell upon the number of chief nobility, that is the local rulers. I have many examples of like this, but what I would concentrate on is after 1619 and between 1619 to 1622-23, there were many ships which were captured by the Dutch while the ships were Indian ships were traveling between Surat and Mocha. So the accusation fell on the English that, look here, you people are responsible. They were not distinguishing between Angrez and Wallandesh. They were saying that you are responsible, so you will have to compensate. This created problem for the English East India Company. Then they talked to the merchants in Surat, and then there was a meeting of the merchants. A meeting of the merchants on 6th of November 1623, in which all the rich and poor merchants of this town, Surat, were convocated and took their oaths on the Musaffaf not to give us more. Mirza Ishaq Beg, Mahmud, Jalaluddin, Ali Razak, Harivanshi could be, with some others would not assent. Sayyid Ali Qazi was the chief herein. And wherein Shafri Khan was and is much displeased and would not suffer him now to come down, though he was very importunate. You will now find Ishaq Beg very tractable. The opinions they sent were the best they could form, and they do not understand why they should be held contradictory. So ultimately an agreement was made, and this is very crucial. It has 15 clauses which which takes into account the general framework of the problems which they might face, or they might have faced earlier, and they might face in the future also. So those are taken care of. The clause number 1 says they shall be permitted free trade as well in ports of Surat, Cambaya, Bhogha, Sindha, Bengala, as in all other cities and places within the dominions of Jahangir Pasha, without prohibition of any commodity to be brought in or exported out of the kingdom, neither limitation confining them either into places, times, or quantities, where, when, or how much of any merchandise, gold, riyas they shall so bring in, carry away or transport from place within or without the aforesaid dominions. A kind of free trade in literatures. Second clause says that there shall no governors, customers, the custom officers, or other officers, for in the name of the king or the prince, engross unto themselves in the way of merchandising such commodities as the English do usually bring, sell in these parts more than what shall be properly needful for use of the king or prince, their sarkars. Then housing was a big problem. They were looking for house on rent. They were always facing this problem right from the day when they arrived on the Indian shores. In Masulipatam, they were facing this problem. Surat, they were facing this problem. So they wanted to sort this out. Each time they would hire some house, and if the local governor or Faujdar is not happy with them, they would ask them to vacate that house. So they were, this was a constant problem with them. So they brought this clause also, that they should be given a house on rent. So it was decided the house of Khwaja Hasan Ali in Surat, with the garden, stable, and other convenience thereunto belonging, shall be let them to lease for the term of 7 years. Earlier it used to be for 3 years. This time it has been extended to 7 years, immediately following the date thereof. They paying for the same, the annual rent is not specified how much. In one of my papers I have calculated that there were many nobles who were giving their houses on rent to these people, to the foreign travelers or merchants, and there were over the period of 50 years there was a rise of 20% of the rent in 17th century, between 1650 to 70. Then they say that they shall have free license either for buying or building in Surat. This is very important because Surat was a shipbuilding center also. Bharuch, Gandivi, of 4 frigates a year, with liberty of their ports, rivers, docks, for the sheathing on careening of their ships. And then they are taking care of the Indians also. At the same time they put a subclause that no materials or workmen who were obviously to be Indians, for performance thereof be denied them for their money. Then the clause deals with the carts and other things. I won't go into those details. Another very important clause is that there shall henceforwards no violence be practiced by assaulting of their house, people, servants, if in defense of themselves any maim of manslaughter should in such case happen to any subject of this kingdom, the English shall be free of any punishment or fine whatsoever for the same. Then they shall quietly and freely exercise their own religion. So they have given the freedom of religion to them, wear arms for their defense, execute justice on their own people. So there is a separation between the two. Though the offense be done to a Mussalman. Their brokers shall have free liberty of speech before any governor to deliver the mind of the English without threats, punishments, interruption, who shall not be abused or daily fined, imprisoned by inferior officer upon slight and trivial occasions. And for avoiding of all future delays in custom house, the goods, rials and other treasure, jewels of the English, as well that which they import or as whatsoever they shall export, they should be facilitated. And for this, they say that they will have to pay 30,000 Mahmudis per year, 40,000 following a rent of 40,000 per year. And another very interesting thing is that in the Mughal Empire, we know that law of escheat was followed very rigorously. If the noble died, then if he had no heir, then his entire property was confiscated to the state, by the state. Here they are concerned with that. As a foreigners, they are given concession in case of mortality happening either unto the chief himself or any substitute of his, whatsoever other degree of the English in general, within the aforesaid territories, the states, whether in goods, money, jewels, or other of the party or parties so deceased, shall remain to the surviving chief the rest of his nation without any seizure or other impediment thereunto whatsoever. And in case of no English left leaving to demand or possess the estates of the deceased, as aforesaid, then shall be the governor, Qazi, or the town, place, therefore, I've just started. Such goods are so remaining. No, I am also taking care of the watch. No, I will finish it, don't worry. Now, these are the kinds of insurance which have been given to them. They have been given freedom of religion. They have given. ISHRAT is very interesting because I examined from Dutch sources as well from English sources, and I found that in no case, the Mughal administrators ever captured their property, or even if they had purchased some land in Surat and other places. Another thing very interesting, I will summarize everything then, since the chair is saying that I don't have time. I will summarize.
It is being prompted by the Vice Chancellor.
Well, I am at the mercy of these two people. So. Another very interesting thing which has come out of my inquiry is that in the case of hundi, how the foreign merchants were dealt. That is very interesting, and I would like to, even if you are not, one case of how they were distinguishing between the Indians who were Indian traders and the foreign merchants. There is one case which they refer to about the Turkish merchants. They said that the Indian merchants were compensated; they were given compensation. The Turkish merchants, they were on the board of that ship which was captured by the Dutch, and they say that when the Turkish merchants approached the local administration, they said that no, you don't have a claim. Then that episode is very interesting. I would like to read this. There were some Turkish merchants who were when plundered by the English on the high seas, came to Lahore, the then seat of the court, throwing their, this is very interesting, throwing their sashes, throwing their sashes under their feet and trampling upon them in front of the high officers of the court. They were told by Khwaja Abul Hasan, the Diwan, finance minister, that they were none of these king's people. Therefore, they should approach their Ottoman ruler for justice to them. But by the time we come to Aurangzeb's time, there is another Turkish merchant, when William Norris has been sent as an ambassador to settle certain issues of these kind of confiscations of Indian merchants, commodities on the high seas. There also we hear about Hamidan Hussain, who is a Turkish merchant, but there is a change. Of course, till the end of the narrative of William Norris, he doesn't say that he got compensation, but it says very clearly that Aurangzeb says that his case should also be considered. What happened, we don't know. As I was saying that this is the difference between Indian merchants and the foreigners, how the state is dealing with both. Another example can be cited from the use and practice of money transfer through hundis. An established customary law appears to have governed the obligations of different parties involved. Hundi was very well established institution and instrument. If there is one evidence, if the drawee refused to pay, then the hundi was returned to the drawer, and the latter had to pay 5% over and above the value of hundi. From another report, it seems that the drawee too was held liable until the drawer paid up. If ever after that, drawee too was held liable until the drawer paid up, and ever after that, the drawee might be called upon to pay 1% of the value of the hundi. Where the hundi had passed through many hands, the person who presented the hundi to the drawee could, on the latter's refusal to pay, demand its value from the person who had sold it to him. And so up the chain, the principal could ultimately be claimed from the debtor. This was in the case of the and now the law of these nations, now it is saying that now the law of these nations, that is India, is in such a case that if a merchant cannot recover in what is due on such bills, that he shall return them to persons of whom he bought them, he purchased them, and receive his money without interest. This custom of the country, this is the observation of the Britishers, this custom of the country was recognized to be different from all others, since elsewhere and in England, at any rate, a person who had once sold a bill was no longer under any obligation to pay anything if it was honored. It was not honored. So there is, there is a major, change or major, say, difference between European practice and the practice under the Mughals. William Norris's embassy I told about, and then so far local, one evidence we have from the Dutch company accounts, where we find at a Pargana level, as you said that at Sarkar level you don't have the Qazis. No.
There is no Qazi
In that case.
In that particular.
There is a reference to saltpeter manufacturers who are, who are saying that, the Dutch merchants have underpaid them and therefore they are not delivering the goods to them. The entire matter goes to Dutch East India Company officials go to the court of the Qazi and they say that, they make their allegations. Then these people who are the saltpeter manufacturers, they depose before the Qazi in writing, and all those documents are available in the archives. I examined them and I found that Qazi goes into them very deliberates on them, and then he finds that the salt manufacturers both were guilty in the sense that Dutch what they had promised they were not giving that much of amount, and these people were guilty of accusing the Dutch of something which was higher than what was agreed upon. So Qazi ultimately settles the thing, and the saltpeters are delivered. This is at the level of the at the very low level of the say Pargana level. So what we find is that whatever was the state of evolution of various customary laws, at least they were effectively followed. This is my conclusion. Thank you very much.
How much time do we have for?
Don't want to leave your thoughts.
I have a question for you. It had always confused me as a former revenue official. That you had Sanat, you had the sort of needs, etc. But was there a very specifically recognized concept of private ownership?
I would argue yes. I would argue that there is a hierarchy of usufructuary as well as ownership rights.
Then, because we are going to proceed further, the sub part of the question which I should have asked, whether the sort of, there were well-defined ownership both for immovable and movable property.
Yes. Yeah. Of course. For instance, we have records of urban property deeds from Punjab, for instance. We have records for that. We have records from in the material that I've seen from Bengal. If you take movable property as even land or houses, urban houses, there are sale deeds for buying and selling of houses in which there is a market. The second question is, of course, to what extent, what's the scale of this? And that one really cannot comment on because there's not enough documentation to do a kind of time series about escalation of property values of the 16th and the 17th centuries. That is not possible. But what is certainly possible is to know that there are 3 or 4 levels at which your right to appropriate, which is basically your fiscal right or usufructual right, and your right to own are both recognized and also recognized in law. That the milkiyat is a concept which is basically a concept of private property. This is mine, then this will give me any milkiyat, which is linked to, in a sense, to a particular kind of landed property which we understand as zamindari. But the idea of malikana as ownership is an embedded concept in this period, absolutely. As is the right of haq. Haq probably is a right to tax, which is a kind of eminent domain, right of eminent domain to tax you, but your right of malikana is your individual right.
And there is freedom of contract also.
Yes, absolutely.
So that looks like.
There's a freedom of contract, but it has to be signed and sealed in front of the qazi or in front of the pandit or in front of the.
The problem which I have faced in law, which of course is increasingly has become archaic, is the rules relating to preemption. Now it appears some of it comes from Muslim law, some from local. That is to say, the sort of Muslim period Indian law also was not dealing to them also. Preemption in some form was not alien. Preemption in a way of course puts major restraints on your freedom of contract. So, I mean, to what extent there was this freedom of contract? Was the freedom more, let us say, in case of chattels or movable property than reality or immovable property?
So that's something that one can think about because there is not enough substantial document. Probably, if you come closer to the late 18th and 19th century, the answers to these would be clearer because the judicial papers are much more dense as you go into the 18th and the 19th century. But then you could also argue that you are working under change dispensation. There is company courts that are deciding over it. But my point is that whatever little I've seen of the further Diwani of other paper, is that even though the company is being presided over by a British judge or a company judge, the terms of arguments are all archaic, if you know, in the sense, what was the traditional practice, what was this. So you go back into the 16th, 17th centuries, but there is a difference in many of these because many of these records saying that from that time this has changed. From the time of Todarmal, the whole usage of revenue terms, etc. has
So
changed.
apparently possession was not a very important factor earlier, which is something which came much later.
Yeah.
The British law. Yeah, no, that must be there obviously, and it can't be an irrelevant evidence, but possession as an attribute of title was not. I mean, you see, subsequently it became, and you
9 point of law nahi tha.
Yeah, I mean, Qasba-e Ghasibana, for instance, adverse possession.
Legal documents mention both together, that this person has the right and possession. Possession is a very important
Because yes, adverse possession was not a concept, it seems, in the earlier time, Qasba-e Ghasibana.
It must have been happening all the time.
No, I think that was, I would argue without being a historian that it should be precisely for the reason that a person who had possession but whose title was disputed was probably the wrongdoer.
Najaf bhai, one is really impressed by this story and the idea we get how the system worked. But coming to after all, they were charged with some crime. So to prove a crime, you need to prove the ingredients of crime. Now, from the story, it seems that we would not look at the crime if someone testifies you are a good man. So FARHAT bhai can testify I am a good man, but I may murder someone. Are you going to say that the question of my identity testified by some people, respectable, non-respectable, we don't know because we are really not getting much idea about that person where this merchant's brother was married, what was his credentials. But why the system did not look at that this is the offense, whether they fulfilled these ingredients or not, whether they were X or Y or Z. that is not important. Or was the crime of Thagi only if you are known to be a thug, you will be punished, we will not look at the ingredients of crime? Because if this was so, then it is a very regressive and primitive view.
On a point of this thing, even in the IPC. No, just a minute, hang on. I mean, in my young age, I read IPC, so subject to memory playing tricks due to vagaries of age. Thagi has not been defined with reference to offences even in the IPC, and Thagi is an offence in the IPC. So, you see, if you talk in terms of Thagi, then probably it was more like this thing, he belongs to a tribe or to a group who are kind of...
No, that is another thing. That there were groups. Yeah, if you are just mere membership, then will complete the offence.
So your ingredient of the crime, kind of a line of reasoning, probably even in the IPC days or in any case the company days onward, does not seem to have applied to Thagi.
Okay.
See, it's quite possible that a lot of things which Banarsi Das does not mention or to which he was not privy, one can speculate. For instance, one can speculate from what happens later when they are liberated, when they are freed, and then the Brahmins ask for their money because the Sarrafs had taken all their money as physical evidence of their being counterfeiters. In which, and they come to know that the Sarrafs have disappeared from the village. So it's quite possible that when this was going on there was already an investigation on what exactly happened, where is the counterfeit money, what is the credential of the Sarraf. The woman also must have been questioned. Now all this we don't have in the narrative. So yes, surely there was an investigation, because later on Banarsi Das was told that, look, we have tried to trace these money changers, but they have disappeared from the village. So now the question of identity, I think it's a very important question, because there is another story of this French traveler Manrique, who was traveling with his party from Hooghly to Gaur, and at Midnapur the party was arrested by the local Faujdar. And these were the days when pirates of Chadgaon were very notorious, and the Mughal administration was also campaigning against them, and presented as highway robbers. And the case was brought, they were charged there locally, and with a letter the party was brought to the Hakim at Gaur, Banja, where there was an investigation which all boiled down to whether anyone can validate your identity. So it was discovered that there was a father somewhere who could validate the identity of Manrique, who was a friar. So a letter was sent to him, another letter was obtained, and then in the presence of the court officials and the officer of the region, they were exonerated from this. And so it's from, and these are solitary pieces of evidence. This is a chance corroboration that the question of identity in such cases as was central. Now one has to find out how much of this concept of identity, how sufficient was this validation of identity.
Are you sure Fatawa doesn't deal with this aspect?
No, there is nothing on identity.
There are all kind of things there. There is very indiscriminately organized also.
There in the Farman and the Fatawa, there is a very important clause which says that the due process of producing witness, validating statements of the witnesses should be followed before you. So maybe this is the witness in this case was the money changer, and the person who brought the charge, party and witness, and the woman there. Now,
If the identity of land, which I believe it was a very, very important factor. You know, this that knowledge. That, I mean, it was not a complete era, identification of land and all that. It stands to reason whether that man is Nawaz Masood or not would also be. Or maybe land was much more important than Nawaz Masoods of the time.
Yeah, so in a society where it's very difficult to prove your identity if you are not living in that village and not, both the big merchant and Banarsi Das repeatedly say that we are reputed people of our town and village. They make this point, जग में व्यापारी भले ठक्के लक्षण कौन? That's what he says. जग में व्यापारी भले means that the world knows that we are merchants. कौन से लक्षण है ठक्के? How can you? What signs of this crime do you?
Interesting thing also would be that I think at that point of time there will be very few cases where strangers would be brought to trial.
No, many strangers were brought.
No. I mean, the point is, out of any given, I mean, let's say, assuming a theoretical situation,
Thieves,
you have some data with
itinerant thieves are always strangers.
No, that's true. But how many, let's say, a case of thievery, larceny, or whatever term?
Many.
Hundreds
of cases.
Most would be known. I mean, the old one of that local.
No, there are known cases, of course, which take place in a town, in a city, or in a village where you have people of the. But there are a large number of cases where you just cannot trace the identity of these people.
In a time of reduced, I mean, lesser mobility, I would say it stands to reason. The chances are that an accused is more likely to be a known devil than an unknown devil.
Well, there are such cases indeed.
There will be. I mean, sure there will be.
There's a famous case of assassination of the Delhi police chief in the early 18th century, who was an Abyssinian, and there was an investigation. And it was found out that a huge payment has been made from the account of a banker to an unknown person. And by investigating the books of the banker, it was traced to a prince. And the investigation was dropped right there. So these are high profile cases.
Was any tribe notified as criminal?
No.
The British will notify number of tribes, the whole tribe.
Identified but not notified. Coolies, for instance.
Akbar identified one tribe, who were petty criminals, and he appointed them as, police person.
No, not police, but guards. Guards. You know that this is a long story in which a particular tribe known for, but the tribe had a reputation of banditry and had given up the profession long time ago, but still were the stigma carried. And therefore Akbar wanted to prove that they are no more bandits, and so he appointed the chief of that tribe as the head of his palace guards. So these are one of those,
if this argument of the enabling state needs to go deep down to look at the nature of the state, in particular issues of the social base of the state, so that the state needs to be seen in terms of its relations with the social forces for this kind of a formulation become convincing. I mean, this is the kind of formulations that have been made with reference to British history by people like Corrigan and Sayers and Braddock, who had been arguing that the state, the nature of the state and the social support base of the state, it structurally changes in the early modern period, and this explains the transformation to capitalism later in the period. So I was wondering if this is an important issue that needs to be taken up as a part of this problem. Secondly, I also thought that once you see economic processes in terms of their relations with the state, how would you then look at economic processes once the state declines, that is to say in the early 18th century, and you have new forms of political formations taking shape?
Well, if I come to your second question first, I would think there is a continuity to the in the way the state and the state subsequently deal with economic phenomena. The parameters laid down
by the Mughal Imperium, as it were, are not really disturbed by the regional states. And much of the documentation that you get from Bengal particularly, which is my area, is from the 18th century onwards, where the processes of registration of deeds, etc., are all being traced back, the lineage is traced back very much into Mughal times. So the terms as well as the constituents as well as the forms of execution of these things are very much patterned along the parameters laid earlier. So there is no disturbance there. There are other issues about regionalization and so on and so forth, but I don't think there is an issue as far as this is concerned, even in states which we not consider to be, in inverted commas, successor. The Maratha state, for instance, has a very strongly embedded notion of private property, right? Particularly banking and so on and so forth, and all the papers that it generates there is much more voluminous, almost at the level of, say, the Bikaner archives, the kind of material that you get in the regional archives on private property transactions in Bikaner archives would be largely Suba Agra and Suba Ajmer, a lot of material from there which is housed in the Bikaner archives. Now, so having said that, coming back to your second question is the enabling state. Now, you see, my point was to take on a kind of historiographical issue here, because very often the argument is that the non-European state is either a lethargic state, couldn't care less, eats, drinks and lives a life of theater, or the other is that it's a state which is intrusive, incubus, and therefore destructive of the economy. Or the third variable now is that it's all right, it's aware of an economy but doesn't know how to manage it, because the economy is something that really doesn't. It's more about culture and about loyalty and legitimacy and so on and so forth. Now that is the way in which, the point is, then the contrary position, the contrast is, look, Western Europe, state mercantilism, protectionism, shipbuilding, warfare, how the state becomes a kind of vanguard of the big economic push in the 16th. But the point is that modernity is not anybody's, as I say, bapoti, It is, it's a global shared experience. And therefore, you have to look for ways in which that can, first of all, either you query the term modernity, which is all right. I'm not querying it. I accept it as an important point to reach. But societies have reached it in a different way. So here, enabling means it's a participatory state. It is a despotic state. So is Europe. There's no doubt. I have no doubt even Akbar was despotic. But the point, nevertheless, that there is a way in which the state then says that, all right, but you guys are also there, and we have to run the system, and we have to run the system by a certain kind of consensus gathering. And a person like Shesha would be very despotic. So he goes to the president and says, I'm giving you a choice, but if tomorrow you don't fulfill, then I'll take the mickey out. मैं बहुत पीटूंगा तुम लोगों को. अभी तो तुम choice ले लो. Decide कर लो क्या करना है. फिर अगर कल तुमने मुझे मुकर गए तो मैं तुमको बड़ी पिटाई करूंगा. So so there is the participation as well as coercion. It's not a kind of welfare state that is operating, but it's not a blood-sucking incubus either. So there is an enabling element there. So as ISHRAT's paper was pointing out, that they protect mercantile property and mercantile wealth quite zealously, and often undue advantage is taken by the European versus the openness of the world.
Professor ISHRAT, this is for you. When you talk about compensation towards given for foreigners or not given for foreigners, I was just wondering, are there instances in the course of your research that you came across how they dealt with subjects of other kingdoms? I'm not talking about non-South Asian kingdoms, but within the Indian subcontinent, because the Mughal state did not envelop the whole of the Indian subcontinent. So were there instances of merchants from other parts of the subcontinent who went through this kind of a crisis where they lost or whatever, and was there a situation of compensation awarded to them or not? How were they treated? Were they treated? Because
I mean, for me, when I'm looking at history, is constantly this whole idea that everyone within the subcontinent was always seen as, one, whereas the outsider is, a European or an African or something like it. So, are there at all instances of any such situation where somebody from another kingdom is in this situation, and were they treated as foreigners and therefore told, go to your ruler for compensation, and you're not a king's subject and therefore we can't give you? I just had that one question.
No, I mean, who would be a foreigner? Why do you say the European is a foreigner?
Europe. Yeah, could be. The problem with us is that we don't have much documentary support for this kind of analysis. But apparently, it seems that they were getting protection by the Mughal state. Otherwise, how could there be so many merchants from Armenia, Armenian merchants in Agra and other places in Chennai and other places? Then there were a whole host of merchants from Iran. Iranian merchants were there. All these were foreigners, and there was a huge concentration.
Within the subcontinent.
Within the subcontinent.
No, from within the subcontinent.
There must have been
From Deccan. No.
Kingdoms down south.
Down south, yes. The problem is that till they have come into the pale of the Mughal Empire, then they were not part of the Mughal Empire.
They were not.
They were not. So
What happened before?
yeah, that's a problem because
there some treaty, at least within the Indian subcontinent. Of course,
Mughal side would
part
fix.
of India was not within Mughal Empire.
Yeah.
So maybe some kind of treaty that our traders will
So
go
there
to
tr-
Europe,
there are
maybe
treaties.
Europe will,
There are many treaties.
So there,
Can I
under the
answer?
treaty, there must have been some protection given to these merchants.
See, it's a very interesting question, and I can't directly answer, but from the first quarter of the 17th century, the Mughal emperors start assuming some kind of a universalist pretension. Hence titles like Jahangir or Shah Jahan. These are universalist titles. So they mention in their memoirs or chronicles that even though they have territorial control over a large area, people living outside this territory within India are also their subjects, and they should be protected. And the rhetoric is that the king, being the representative of God on earth, should look for the protection of people even when they are not technically, if at all there is a very strong concept, subjects. Now here they are making a distinction between Indian and European merchants. So that's one very important distinction of foreignness and Ottoman. No, sorry, there is something else. Then there are territories signed with local chieftains, like the chief of Bhuj, or Kathiawad, or Baglana in Sahyadri, or other chiefs where this protection granted to merchant is a very important.
Sorry. So I have a big question, and it's partly out of my ignorance of the field. I'm really delighted to actually have four papers that four papers in Professor Hasan's papers that talk about law in the pre-colonial period. And one of the challenges of thinking about South Asian legal history is all of it basically begins with the colonial period and on the sort of notion of what lies before. So my question is basically, one is a historiographic question: why hasn't there been more work? And sort of apart from Professor Hasan's book, the only book I found was by M.B. Ahmad from 1949 on Mughal law and administration. So compared to especially the Ottoman work on the Ottomans or the Chinese or contemporaries. So I get two answers. One is that the documents and archives don't exist. Now
We are lethargic too.
so the second bit, of course, so if they don't exist, then does the absence then tell us something about law in the Mughal state, or are there ways in which you see that the field might develop in the next few years?
Who wants to take this up?
I will make a quick comment. I think the documents exist. It is just that the historians haven't bothered so much, because partly it's because it's seen as crime and punishment
Right.
kind of thing.
Right.
That you do, or you murder somebody and the state says decapitate him. Crime and punishment, that's where, but law is not about crime and punishment. It's about many things including crime and punishment. So I think that's, the approach has not been, right? And perhaps the reason why there's not been too many such conferences we have been invited. So that is that's a hint to you, sir.
Take it forward.
Otherwise, I would not have bothered to look into the documents. These are all well-studied documents, but I look from different angles.
Take that.
You have mentioned the Ottoman historians. There is nothing like the Qazi Daftar record. So that's one major. People have spent their lifetimes studying Qazi Daftar record, not only in Istanbul, but in Anatolia or in the Ottoman, Egyptian, Syrian region. So there is no such thing as Qazi Daftar record.
Because they didn't have it, or it got
It disappeared.
Okay.
All the proceedings were meticulously documented, and that we know from the reports of news writers who were sitting there. A filtered account of cases about which they wanted the emperor to know are already there. There is a very important manuscript sitting in Hyderabad, which is a huge volume of news reports, which meticulously documents cases brought to the court of the Qazi or the Fajdar. So the documents are there, but they are not enough. So that is one major reason why it has not inspired many. But even when these documents, which are filtered versions, they have not been studied. So it's a bit of a both. We don't have the kind of archive which the Ottoman historians have, particularly in legal matters. But we also have this manuscript sitting right here, and nobody has bothered to write anything on that. No, these are not akhbarat. These are the opposite of akhbarat. In akhbarat, you relay information from the court to the province. Here, you have the entire Mughal Empire where news reports are coming to the center. So they are very important documents.
I also feel the project of the construction of the nation state, and there was this anxiety to place legal history within the framework of a constructive narrative of its, of a modern or pseudo-modern formation, so that, the modern nation state can be seen as emerging not from the colonial formations but from the Mughal formations. And this meant that you would have narratives that would center on the state, and this would obviously lead to a kind of a narrative in which legal history would be a subset to process of state formation. And much of the legal work that did come up in the 50s and the 60s was for this reason focused on the textual tradition and as against the actual practice.
That is interesting that documents called as legal and constitutional.
Exactly. You got it right.
Often the most boring courses.
Yeah, it's usually the most boring courses.
Because that's constructed by lawyers and judges. I mean, MP Jain, Ramat Joyce.
For civil service exams. So
when I joined law school, I just completely chucked the entire course out and I reconstructed and I thought you should talk to law students.
You took the
I couldn't teach it.
You took the history component seriously.
So thank you very much for all the papers. And if we are delayed for lunch, it is issue column.
No, but